analysis. And again, just to reiterate, a part of what it is to be an independent contractor is you're usually hired for a specific project or series of projects. And the term of employment is, I shouldn't call it employment, the term of the contract relates to the completion of the project. The person that is receiving the services or tasks to be performed don't control how the contractor, the independent contractor, perform them, or under the time constraints, the actual schedule for when things to be done. It is up to the independent contractor to set those terms, unless the contract clearly defines those things. And the more control the party has that made the contract, the person receiving the benefits or the services, the more likely it'll shift into an employee-employer relationship, even if it's short-term. Controlling of hours, controlling how the task will be performed, those kinds of structures and sort of rubrics will determine whether it's an employee-employer relationship or whether it's an independent contractor. Why are we concerned? Because the person hiring an independent contractor is not liable for the acts of negligence and torts that the independent contractor conducts while they're in the course and scope of that contract with the party hiring them, whereas an employer is often responsible for the acts of the employee when they're in the course and scope of employment. We'll get to what course and scope of employment means. And there's a lot of case law in it. It's kind of an interesting area because it's not always clearly defined, and a lot of case law comes up and questions come up all the time. Was that person actually in the course and scope of employment when some incident occurred? And it's a question of fact to determine by the circumstances, but there's a lot of case law that develops over time determining whether, for example, somebody playing at a company softball tournament for their annual picnic they have in the summer on a Saturday, the question is whether they break their leg during it, are they entitled to receive benefits potentially because the injury came out of the course and scope of employment? Well, it doesn't sound like softball is part of your job if your job is to be paralegal or an attorney or something to that effect. But at the same time, if there's a real expectation that you participate in these activities, you may well have been in the course and scope of your employment time. Thing that I have had a lot of dealings with are things like you park your car and you're entering into the building where you work and you slip on ice and get injured. Is that a work-related injury giving you potentially workers' compensation? And there's a lot of case law on that, and it ebbs and flows. But you can see it's not always a clear-cut test, but we'll get to that in a second. I jumped ahead. So the creation of the employer-employee relationship, it's a contract, and basic contract law principles apply. Over time, a lot of the rules in customary principles under the common law have been modified by statutes, and mostly to protect the employee, because we know for a long time freedom of contract usually the employer had more strength in the bargaining situation, and they often took advantage of employees, not to be cruel or abusive, but it's just the nature of the capitalist system we have. If I can hire somebody at a very low, impoverishing wage, I would. So we came up with things like minimum wage standards, and OSHA came in with the Occupational Safety Act, where work sites have to provide for reasonable, safe environments for the employees to work at, so they don't have to surrender to risk and harm simply to earn a living. But the relationship, when it happens, it can be via a contract in written form, and it can be implied, or it can be a combination of both. What do I mean a combination of both? Well, part of it could be written, but some of the aspects of it, the terms, the length, the duties, might be implied by the nature of the employment that you've been hired for. Not everything has to be spelled out in great detail, and it can be simply implied. I mean, I guess it doesn't happen too much, but what if I was like I don't know why I always use landscaping companies, but say I had a landscaping company, and one day, I got a crew of maybe 6 or 7 people that work with me, and one day there's somebody in one of the quad cab trucks, and who's this? And goes, that's my friend, he's going to help us today. I'm kind of like, all right, and I don't really object, I don't really say anything, and I don't agree to it, but during the course of the day, that person works, and they show up the next day, and the next day, and the next day, and I cut them a check at the end of the week or the 2 weeks, however the payment process is. They probably, by implication, have become an employee of mine. And again, it's usually contextual. A lot of things in law are contextual. You can't just say this is the rule. You have to apply it to a contextual situation to see the nuances, because when you have a rule, it sounds easy to apply until you get some unusual contextual situations to determine whether or not something is either true or not true under that application of that law. So it can be oral, it can be in writing, and it can be implied by the behaviors of the parties. Now, how about the length? And I think this is a little bit confusing in the book, and the book is usually very, very good. But the length of employment, unless the contract says otherwise, this would be a 1-year contract, this would be a 2-year contract, a 6-month contract, or you're a permanent employee. If it doesn't say anything like that, generally both parties are an at-will situation, meaning the employer has every right to terminate you at the end of the length of the employment. Well, the length of the employment's at will, so it usually is, many employees are hourly. It's at the end of any given hour in theory, but it's really at any given moment. Even if you're paid biweekly or monthly, usually that's considered the term of your employment. If you're paid monthly, you have a monthly contract. If you're paid weekly, it's a weekly contract. And in theory, unless you've done wrong as an employee, the employer can't fire you till the end of one of those periods of time have expired, giving some window. But that's the common law principle. The common law has been largely amended that if you don't have a specific express contract in terms of the length of the contract, it's an at-will relationship, meaning the employer or the employee. Most people focus on the employer and say, well, it's really wrong to have an employer to be able to just fire someone, even if they're doing a decent job and they're working well and they're doing everything they're supposed to do. You're telling me the employer can just simply fire that employee? Yes, under the common law and under most statutory authorities today, it's an at-will relationship. How that can change is usually through collective bargaining. What collective bargaining is usually through a union contract, but it doesn't have to be union. I, as an individual, might want some job security. So if they want to hire me as an attorney for a certain firm, I'm worried about some job security. I'm worried about paying my bills. I don't want to show up one day and the boss say, pack up your things, today's your last day. Could they do that? If there wasn't a contract to the contrary, yes. So sometimes people go in and negotiate a 3-year term, or there's a union contract, and then there's certain principles that the employer can't fire you unless certain events occur, like there's not work available, or you do certain things that are contrary to the contract's terms. And I do some stuff, I have done some stuff with the union, for example. The college that I work at now, Mount Wachusett Community College, you guys know that, you're in this class, and we have a collective bargaining agreement, and most of us are terms of 1-year employment until you get tenure. Then you're a permanent employee. They can still terminate you, but you have to have certain events occur, like you don't have students to teach, maybe your program's dried up, there's not work for you anymore. Then there's a process by which termination can be had, and there's timelines for when notice has to be given, procedural principles have to be applied. And why we do that, why unions often fight for what we call these collective bargaining agreements, is to give a sense of security for both sides so we can plan accordingly. But most people, the great vast majority of people who work out in the workforce, are employees at will. My sister was educated, very smart lady, and older than me, and we're still very close. I remember her getting terminated from a job she had, and she was outraged because she was a really hard worker and really dedicated, and it really devastated her, and she wanted to sue. And I was just getting out of law school at the time. I really didn't know enough, but she hired an attorney who I actually know now pretty well, and he thought she had a good case. But I remember, studying law school, I said, well, I thought she was an employee at will. Unless what? The employer fires you for one of these things called bad faith. And it usually relates in most circumstances to things like race, color, creed, sex, sexual orientation, your religion, things of that nature, these protected classes. They can't fire you for that reason. But what if the boss says, every time I come in here and I'm working with Jim Corman, he just gives me makes me feel uncomfortable. He's always uptight. He seems always nervous. He's just, I own this company. I shouldn't have to feel that way about this employee. And it's not because of his race or his ethnicity or his religion or his age. It's just that I like the guy. Can an employer fire you for that? Yes. It's not part of the protected class area. So most people focus on that seems fundamentally unfair for the employer. And that's why we as everyday people sometimes get rights together and we bargain collectively to help create job security. My father was a big union guy, so I'll tell you my bias. I'm kind of pro-union, and I recognize there's all kinds of reasons not to be pro-union. But one thing I grew up in fear of was my dad, growing up, was my dad always talked about job security. Imagine waking up one morning and someday your boss just doesn't like you, and you had a job security, you have a mortgage, and you're paying bills, and you have a family support, and the boss just comes in one day and says, hey, you're through. That can be catastrophic to somebody. And so even though I have tenure, and we'll talk about this class, but tenure is a type of contractual job security that heightens my ability to retain my job unless I'm really committing wrongdoing or there's simply no work available. So anyways, I'm way off track. But we know the old song. I always hated it, and I think I mentioned it in this class in another chapter. The whole concept of, I don't know if it's, I'm not a big fan of country music, but take this job and shove it. It's the same principles also true for the employee. Think about it. If you're at work one day and you really hate where you work and it's disgusting, and maybe you have another opportunity somewhere else, none of us seem to really feel too bad about the employer when you come in and say, hey, today's my last day, I'll see you later. I mean, it's rude, it's probably inappropriate, especially if you leave the employer in the breach, so to speak, because they don't have someone to fill your position. And I don't know, maybe it's a very critical job you have. But that's the power of an at-will contract, and most contracts are at will. What can't they fire you for? Those protected class reasons. And as a society, we've kind of accepted that. Generally speaking, we're free to contract whomever we want, and we're free to undo those relationships. Can't be forced to work for an employer. But now, what if I had a term of 2 years? I was required, say I was required to work for I had a 2-year contract with some law firm. I'm an attorney for them. And, in the middle of it, for whatever, I hit the lottery or something, or another job opportunity comes up, I really want to take it. And so I quit. Have I breached the contract? Yes, the employer can sue me. They can't force me, though. The remedy is not to force someone to do work. That's actually banned by the 13th Amendment that ended slavery. It also ended a form of what we call indentured servitude. The requirement to work for somebody, even for pay, is banned by the Constitution. But that doesn't mean they didn't breach a contract. So they could sue me for the damages they suffer. So maybe to hire somebody that has my skills and experience and to catch up on the work costs them an extra $10,000 a year for the next 2 years. They could sue me for those damages they want. They often don't, but they could. The opposite is also true. What if I have a 2-year contract? I'm managing the Red Sox for 2 years, and halfway through the season, it's really going miserable, and the players are revolting against me, and management comes in and says, "Jim, we got to fire as a coach." I said, "But I have a 2-year contract." And I said, "Well, I'm sorry, but guess what I'm going to be able to do for the next year and a half? Collect my wages, because they fired me in contrary to the contract." Now, sometimes they try to put in the contract that they can fire you if you don't have a winning record at a certain point of the season, but very few people are willing to take those kinds of performance contracts because it gives so much power to the other side to terminate the contract. So the length of contract, again, it's by either the term itself or it's by the way in which you're paid. But the common law, unless there's a specific thing you're tired for a year or 2 years, most contracts are, again, at-will employment. Both the employee and the employer have a right to terminate any time. The duties and liabilities of the employer, the book's straightforward, and the law is pretty straightforward in that. Duty to exercise care. Basically, they shouldn't have a negligent work environment. They have to act reasonably under the circumstances. Not perfect, but it has to give you a reasonably safe work environment in there. And the government actually steps in, and a lot of people don't like that because a lot of people think we have a totally capitalistic system that's laissez-faire and the government stays out. It's not true. The government gets involved all the time to inspect work sites, especially construction sites, to make sure they're fundamentally safe for society, employees to work in. Duty to provide a reasonably safe workplace. That's related to exercise care, and that's some behaviors versus the actual physical plant or office and things like that. Duty to provide safe tools and appliances, pretty straightforward. Duty to provide competent and sufficient employees for the task. Getting to workers' compensation from I always had a case workers' comp. They were making this guy move 200-pound, I don't know what they were, but they were these big objects in a factory, I think it was barrels of chemicals. And it was just with a hand trunk, and they were not very easy to get on the thing. And we sought workers' comp, but we also sued them under this concept because they didn't provide a reasonable amount of workers to accomplish the task at hand. And we had a worksite visit, and we got to show the nature of the work. And it was really amazing that he did it for that many months he did before he injured himself. And that was a violation of that common law principle that they have to provide enough workers to actually perform a function reasonably. And a duty to instruct employees with reference to the dangerous nature of the employment. And that's kind of the thing, like, geez, they put me in this machine, next thing I crush my hand on it. You're going to get workers' comp. That's a separate issue. We'll talk about that shortly. But you might actually be able to sue for failure to instruct because there's a reasonable expectation. You can't put somebody in a very complicated machine that's dangerous in its nature without giving instruction. Common law defenses. I don't know why we study this unless you like history. I'm a history professor at the Mount too, and I love history. But there used to be these defenses that if the employee was contributory negligent, they couldn't seek workers' comp or benefits, meaning Maybe when I crushed my hand, I was goofing around and I wasn't using this safety device in the process, so therefore I contributed to the nature of the loss through my own negligence. Under the common law, the employer would have an absolute defense, even if I was only like 20% at fault, but they were 80% at fault, like, kind of comparatively looking. That's why we call it comparative negligence. That's abolished now. If the employee is negligent, but they're trying to further the interest of the employer, they're going to be eligible to get workers' compensation and get benefits from the employer in the relationship. So that's been abolished, but at one time that was a defense. The act of the fellow servant, that's gone in Massachusetts, definitely. I think in some jurisdictions there's still a defense, meaning that the employer had nothing to do with creating a negligent situation in the workplace, but my coworker, it was their stupidity, their intentional act, their negligence, whatever it was, and I injured my leg as a result. Now I can't work anymore, or I'm going to have a leg injury for some time to come. Can I sue the employer? Well, under the common law principle, the employer could say, well, it's not our fault in any way, shape, or form. It's an act of a fellow servant, a coworker. That's gone. So I don't know. It's kind of an interesting concept, but I don't know why we study things that are gone, but it's gone. I know why in history, but why in law if it's no longer really salient for you. And the risk assumed by the employee, just like in traditional tort law, if the employee says, I have a quicker way to get all this equipment down in the lower thing, I can kind of jump over with a rope like Tarzan and kind of swing down with the boxes, and I don't have to keep going up and down the stairs, and I'm going to do it every time. One time you do it and you fall and you break your arm. You assume the risk. You knew you were engaging in something very dangerous. It wasn't required of you to do the task, but you decided to assume the risk. And that assumption of risk has caused you to basically cause an injury, and that would be a defense for the employer. It's gone now. If you're long as you're in furtherance of the employer's goals, even if instructed to do otherwise, this surprises a lot of people. Employer says you have to do it this way, but you decide to create a shortcut that creates this dangerous situation. It's kind of your fault. It's a faultless-based system now. It's no fault. If you're hurt in the course and scope of employment, even if doing something inappropriate, long as it was in theory to advance the interests of the employer in the long run, you're entitled to workers' compensation benefits. And we'll get to that in a second. So again, modification of the common law defenses. We don't have that anymore. An employer has liability, even if the employer is contributory negligent. Already said that. And a lot of people don't like this rule, but the more you think about it, it's really a good principle. In Massachusetts and every state in the union, I think you're required to have a workers' compensation insurance if you have employees. And what it is if your employee is hurt in the course and scope of employment, they're entitled to benefits if they're injured and unable to work. Now, it's no fault. It doesn't make anybody rich, meaning the employee is only entitled to basically lost wages and something called loss of function. So if I injured my arm and say I'm a construction worker, so I can't work for a period of time, I'm basically going to get my lost wages. It's 66 2/3, I believe, of your lost wages. If you're totally disabled, can't do your work anymore. And it's only temporary for the period of time that my arm is injured. Now, what if after my arm heals, I've lost 10% of its use? Workers' comp actually pays you the value. There's actually a formula for what the loss of 10% of your dominant arm. If I was right-handed, it was my right hand I injured. But again, there's no fault required. But what does it mean to be in the course and scope of employment? What if while I'm at work, my job isn't to move pallets or anything like that, but I'm a machinist and I work on a lathe and a millwright thing. But for whatever reason, I said, geez, those pallets look really ugly against the building. And I think when our customers come in to buy our products, those pallets look terrible. So I'm going to take 10 minutes. I just finished a project on one of these, and I'm going to move those pallets with a forklift. I get the forklift out, I'm moving the pallets. They fall over. They hit me in the head. I get a serious concussion. I can't work for a period of time. I was doing something that's not related to really my direct task at work, but would I be eligible for workers' comp? And the simple answer is yes, because I was furthering the interests of the employer, even though potentially unauthorized, and maybe even I was doing something that my employer told me not to do. That surprises a lot of people. As long as I'm not doing something to actually overtly injure my employer's interests, or I'm not willfully doing something to intentionally hurt myself to get workers' comp. And I always say anybody that does that's got to be a fool, because workers' comp does not give you a lot of reward. You have to be injured, and it's usually based upon medical records. And the other thing is it has to be something that only awards you the amount of your lost wages. You're not entitled to a windfall for workers' comp. The only time there seems to be a bit of a windfall is, say I'm injured and there's not a clear, I've got torn rotator cuffs, and maybe I'm never going to be able to really do my job the way I used to be able to do, and I'm eligible for years of workers' compensation benefits in the future. Sometimes we settle for all those future benefits, or a significant amount of those future benefits up front, close out the case and they get what's called a lump sum. Sometimes that seems lucrative for the employee because now they're free to go work in another industry or another type of employment they can do. But for the most part, workers' comp is only designed to put the employee in a position they would have been in if they hadn't been injured. It's not really supposed to be like, oh, thank God I got hurt at work, I'm going to be wealthy now. It doesn't work like that. It surprises a lot of people. It's really designed to be fair for employees to be able to maintain their life, but they got hurt at work. It's and some people say, well, now through no fault of their own. It can be through their fault. They could be negligent. They could be careless. They could be stupid. But as long as it's within the course and scope of their employment, they're entitled to workers' compensation benefits. I used to do a lot of workers' comp. I don't like it that much because there's a lot of little Byzantine rules involved in it. But one of my closest friends right now got in a very serious auto accident while working, and he hurt his neck, and he's got a bulging disc coming in. The woman that hit him actually perished, passed away. Very serious car accident. He's been not working for a period of time, and he's collecting workers' compensation benefits right now. And he's so upset. He goes, I want to go back to work because he can't get his overtime because his overtime is not subject to what he gets on workers' comp. He just gets entitled to what his base pay is, and it's really frustrating because he had a lot of overtime in that job. And then we have the Occupational Safety and Health Act. That's OSHA. Employers hate it because some things that don't seem necessarily unsafe to me or you, there's a lot of technical rules on how work sites and work atmospheres have to be to make sure they maintain safety for employment. And if the employer's not, they can be fined substantially. And it also allows, so say I was hurt at work, now I'm going to collect workers' comp. But if OSHA investigates and determine that the employer was negligent in the way they kept their workforce, I might actually be able to sue in straight tort, like for negligence, above and beyond workers' comp, which gives me money for what's called pain and suffering. And that sometimes can put money in the employee's pockets beyond that of workers' compensation. Liability of third parties. And that's the big thing with employer relationships. If I'm in the course and scope of employment and I'm an employee, say I'm working for the Mount, and my job at the Mount is, I don't know, I go and get office supplies and do different things. I'm kind of a runner. And I have let's assume, to make it even clearer, I have a state vehicle with the Mount emblem on the side of the car, and I'm driving and I'm speeding, and because I really want to rush and get the job done. I'm not acting completely recklessly, but it's in my hourly wage time, or my duty time. I'm 8 to 4:30, whatever the schedule is for a traditional worker like that. And I'm driving too fast. And I'm going up near that rotary near Haywood Hospital, and I'm negligent, and I crash into a nice car, and I injure or damage that very expensive car, and I injure the occupant, and they break their leg, and they suffer some serious physical injuries. Am I liable individually? Yes. But who else is liable? The employer. That's the fear we have when we have employees. If they're in the course and scope of their employment, they are going to make the employer liable, as long as what I'm doing is to further the interest of the employer. Now, what if while I'm doing the work, I have a lot of latitude, I don't have much oversight, bosses that micromanage what I'm doing, and while I'm out driving, say I have, I collect baseball cards. I don't know. I collect baseball cards, and I'm going to stop in at the baseball card shop, and when I'm going in there, I'm on the clock with the Mount, but I'm not going in there to further my employer's interest in any way. I'm just going to buy some baseball cards. I heard was in this little collector shop. And when I'm in there, I act negligently in the way I walk. I trip, I knock down an elderly person, and they break their hip. Would the Mount be liable there? Well, although I was on the clock, I wasn't really in the course and scope of my employment because I wasn't doing anything authorized by the employer, and I wasn't in the course and scope of my employment because what my acts that I was doing wasn't to further the interests of the employer. Just like what if I was driving down the road and I saw I don't know if people do this anymore, but when they were younger they did. I see my arch enemy, the guy I fight with all the time in my community. And I said, well, geez, I got time before I have to get to Staples to buy supplies for the college. I'm going to pull over and I'm going to have some fisticuffs with this guy. And I pull over and get in a fight, and I break his orbital over his eye, and I break his nose because I'm such a great fighter. And would the college be liable? Because they want to sue me, and maybe I don't really have any assets and I don't have insurance to cover that kind of claim. They might want to go after the deep pockets, the more affluent college who I work for, or maybe it's a private company, whatever. There I wasn't doing anything in the further the interest of the employer, and it wasn't a permitted task, and it wasn't designed to, again, some way advance the goals of the employer. So I'd be liable, but the employer would not be. It's almost a common sense application if you really think about the analysis of it, because there's been cases where people have done some horrendous things, well, technically on the clock, but it wasn't in any way, shape, or form designed for furtherance of the employer's goals. I'll tell you one that was actually not allowed by the employer, and it was banned by the employer. There were strict rules against it, but the employer would still be liable. It was a case I wasn't involved with directly, but I love the facts. It was like a convenience store, and young teenage people were hanging around with skateboards, and back then people carried those I guess we call them boom boxes, playing loud music, and it was scaring away all the traditional customers because these, young sort of hooligans were hanging around outside the store and coming in buying matches or, just something stupid just to kill time. And so the clerk that was there was told, never use physical violence, never do anything. If people are loitering, call the cops. So he starts to get frustrated with these kids because they're always there. And he tells the kids to get out of there, and they just refuse to leave. And he, for whatever reason, had a baseball bat with him behind the counter, and he comes out with the baseball bat and kind of threatens the kid, but the kid picked up the skateboard and kind of like got in a defensive pose, and they went to town. They really beat the crap out of each other, and the store clerk got the best of it, meaning he beat it was 18 or 19, beat the kid pretty bad. Well, the kid's family sues. Well, who did they sue? Well, they sue the clerk, which is a really good case, but then they sue the store. Let's say it's 7-Eleven or Cumberland Farms. It's not neither of those stores, but they sue the store because that's where the money is, right? And the store tried to argue, well, what the clerk did was not only not authorized, it was actually banned under a policy which he signed, and so therefore we shouldn't be liable because what he was doing, getting in a fist fight with a baseball bat or getting into fisticuffs with weapons, had nothing to do with advancing the interest of the store. But the judge actually made a ruling, goes, but what he was doing was trying to clear out these people so the store could function and allow customers to come in and feel unintimidated, and found that liability could be had. The case settled before the jury actually got it because of the judge's ruling to say, at least on its face, there's an argument that is in the course and scope of employment. That's the big thing from this chapter. When is the course and scope of employment? Had, if you will, or established. Now, employees' duties, job performance, they have to do it a reasonably good job. It's kind of a fiduciary obligation. They have to do it the best they can with the skills and the instructions that they have. Business confidentiality. If there's trade secrets, methodology by which they do something, they can't share it with a competitor. Even if they didn't sign a confidential agreement, it's automatic in law. Inventions, that's a curious one. I often put a test question on there. If you're hired to actually make inventions, to make processes for the employer owns those inventions. But most of the times, employee, maybe an engineer or somebody has skills like that, they're employed to do certain tasks, and along the way, that employee develops certain processes or machinery or something like that. They invent something. The employee usually owns it, unless the contract says otherwise. And if the contract's silent, again, they weren't hired to make that invention. They were hired to do something else, but an invention was discovered or completed during the process of employment. It's owned by the employee. However, the employer does have license to use that invention in their factory, but they can't do what? They can't make multiples of it. They can't use it at other subsidiaries, and they can't sell the invention. That's owned by the employee, and it's called a non-exclusive license. Why non-exclusive? The employee who invented it could now sell it to others because it's a non-exclusive license. A lot of people like to talk about inventions because it can be obviously very, very lucrative. And then the chapter segues a little bit because it does relate to employment, some of the federal Social Security Act. And this all came during FDR's administration, one of my favorite presidents. And a lot of people think it's communist, but most people look back at history and say, if it wasn't for that, we wouldn't have got out of the Great Depression, and many elderly people especially would be struggling if they didn't have family to take care of them. Back in that era, many more people did, but I can only imagine a lot of people don't have pensions, private pensions and retirement plans. The retirement plan is Social Security, and that was created in the 1930s under the Federal Social Security Act. So one is old age and survivor's insurance. You want to hit a certain age, usually it's 62 to get a minimum amount. I believe it's bumping up soon to 70 for the higher amount. And why is it bumping up? It's not because we think people are living longer. Like my kids say, oh, it's going up higher because the higher expectation of living longer. No, it's not. They're running out of money, so they got to try to find a way to save it. So they're trying to bump it up. At some point, I wouldn't be surprised if it goes to mean testing, that if you have your own wealth and maybe a prior private pensions or something like that, in order to save Social Security for those that really need it, there might be means testing in the future. There's not right now. You could be extremely wealthy, and if you paid in your quarters, it's usually 10 quarters. And there's 4 quarters in a year. So you do the math, you got to work basically for that period of time to pay into Social Security. You're eligible when you hit that age. Obviously, the more quarters you paid into and the more income you made, the higher your Social Security benefits are. But these aren't to make anybody rich. It's the way to keep a safety net so elderly people don't become basically beggars on the street. And it was done in the 1930s, and it's very, I think for the most part, a fairly popular law. You pay into it, you should get it back out. The survivor's benefits, for example, if somebody dies relatively young and they paid in and they had a spouse or minor children, those minor children's spouse will receive benefits because we don't want them to become impoverished because the breadwinner, the mom or the dad, had died prematurely before the age of retirement. If they hit the age of retirement and they pass, only the spouse will get the money. In minor children. Assistance of persons in financial aid, that only applies to people 65 or older. Sometimes they get supplemental money, even if they haven't paid in their quarters, simply because they're so poor. We don't want people to be impoverished. It's a safety net. Some people call it welfare. I don't really like that term because it's become a negative connotation. But we really, as a society, what do we want people to be? Becoming homeless and having no ability to feed themselves. I mean, and just bank on the charity of others. Some people think that's the better approach. I don't know, but we do provide that for people who are 65 or older in a financially, make it supplemental security income beyond the quarters they've paid into. Also, blind and disabled people. I used to do a little bit of the Social Security disability work. If you're incapacitated, even if you haven't paid in your quarters, if you're incapacitated from physical ailments, and the physical ailment test is very, very challenging. You really can't do any meaningful work at all. You really have to be significantly injured. Blind is a little bit easier. The blind status is a little easier to get people on a form of Social Security benefits because you're unable to see. But I've had people that had back injuries and everything, so I couldn't get them on workers' comp because they said, well, you could do different kinds of jobs that don't require you to have a healthy back necessarily. The last time I did one, I haven't done this in 25 years, but the last time I did a physical disability to get Social Security disability benefits was a guy with very, very brittle diabetes. And the medical, it's usually driven by medical reports. His brittle diabetes were so severe that when his sugar was off, he was young too. He was only in his 40s. He could like fall asleep right in front of you from, I don't know, too much insulin or too much sugar. I don't know how that works on him. And he couldn't walk up the stairs at night because of his legs would get very, very weak. He couldn't drive anymore. It was a really, really sad case. I had to take that all the way to the appellate court to win because they often said, well, he could do these different kinds of tasks at different times. And it was really very, very, very difficult. We won, and I was one of the happiest cases I ever had. It wasn't because I made money, and I did, but it was much more because just a good guy. And I was really, really happy for him and his family. Got him on workers' comp. Not workers' comp. Disability on SSDI, Social Security disability. The other aspect of it is not always physical, and this is a little bit more getting more and more prevalent. People have serious mental health issues that prevent them from working. Either I had one guy, I think it's called agoraphobia. We became pretty close friends in a way, actually, many years ago again. And I'm looking at his job record, and I got all the material together, and he had like 8 jobs in 1 year. And I ended up contacting some of the employers. It was always great. Then one day just didn't come back to work. And so, yeah, it was going. He'd get this anxiety, and he just couldn't go into work. So he was meeting, fortunately, with a psychiatrist and a psychologist, and they all backed up that he had this diagnosis that he would get just tremendously anxious to have to go do these things. Very bright guy, really, really smart. And because of the medical records suggesting that his mental disability prevented him from working in any meaningful way, we were able to get him on Social Security disability benefits. And I believe that's a good thing too. You just can't let people languish. They can't work. They should have at least a threshold of some kind of a way to function. The one that's very interesting is unemployment compensation. This is a big one. I used to do appeals on this a lot. You have to work 15 weeks. That's the minimum in Massachusetts. I mean, don't quote me. I'm not going to test you on Massachusetts law, but it's 15 weeks you have to work, and you have to have made at least, I think, $3,500. And then now you find yourself unemployment. You get fired. Your employer either maybe work ran out, they don't need you anymore, or they just think you really suck. You're eligible for unemployment. It's not about, and I've had a few employers because they can object. A claim comes in, the employer pays into the system, and the employer can object. And they often object saying, this person was so bad. They were screwing everything up. They cost me money. They were idiots. They weren't showing up on time. They were always late. They ruined some of my products accidentally. the employee is entitled to unemployment benefits. It's only when the employee was terminated because they were doing something in contravention of the best interests of the employer. They were stealing or maliciously destroying the products of the employer or the machinery of the employer, then they wouldn't be entitled to unemployment benefits. The one that's very, very difficult is oftentimes an employee finds it very difficult to work for an employer because they're mean and they're nasty and they hate it working there, and they feel like they've been constructively fired. They weren't fired, but what do? They felt like the employer hated them so much that they feel like they had to quit. And now they go to seek unemployment benefits, and the employer says, but because I didn't terminate them, it was a voluntary termination of employment by the employee, they're not entitled to unemployment insurance. And that's true. So sometimes, though, we can create a situation where, although the employee said, hey, I quit, I can't take this anymore, the employer really created the situation. That's a very difficult burden to establish by the employee. But anyways, you have to have been employed for a certain length in Massachusetts, 15 weeks. Be capable of working. You can't say, oh, I hurt my back skiing after I got fired and I'm not able to go work anywhere else. Thank God I got fired the week before, so I'm eligible for unemployment. In order to get unemployment benefits, you have to be willing, able, and eager, for lack of a better way of saying it, to find employment. Be capable of working, not having refused reasonably suitable employment, not be self-employed. There is some methodology potentially getting unemployment benefits for self-employed, but it's very rare, very difficult. Not out of work because of a strike or lockout, and had served the required waiting period. I think that's 2 weeks. You have to wait 2 weeks before you're even eligible to go and seek unemployment benefits. And you have to be actively seeking employment. I don't know the rules now. I don't think they're anything like they were when I was a young person, but I had a job and we used to get laid off periodically because it was kind of seasonal, but it's seasonal. You're usually not entitled to unemployment benefits. So me and he became a close friend. His picture right behind me, he just died 2 years ago. He was much older than me, but kind of became a mentor. He's a funny guy. We used to have to fill out these forms of all the places we look for employment in order to get an unemployment check. And you'd submit them, and then they would cut you the check after proving that you were willing, able, and physically able to go and look for work, and that you had. And so his name was Stanley, and Stanley has his list, and he's got it out. And sometimes I used to think he was a little slow, and other times I thought he was brilliant. This is one of the times I thought he was brilliant. He's showing me where he applied. He applied to be a vice president of a bank. He applied to be like was a director of a hospital, all these jobs. Stanley had a high school education, and he was a very funny guy. He was a physical laborer for the most part. And I said, you applied for those jobs. You weren't going to get those jobs. And he in turn goes, exactly. He didn't want to go to work. He actually enjoyed this system of collecting unemployment benefits every year for a period of time for many, many years. He's quite a character. I've always felt guilty. I couldn't do it. I actually tried to look for employment during that time. But anyways, that's unemployment benefits. Disability Medicare benefits. I talked about that. Medicare, you get at a certain age. Oh, and how is the plan financed? It's usually through payroll deductions. Money goes into the federal government to pay those to those funds, and you see those on your traditional check being removed. But that's all covered there. They talk a little bit about the Affordable Care Act, which is a little bit, I don't want to say it's in limbo, but it's changed somewhat. This is basically trying to create a system by which if you have, I think it's 50 or more employees. Yeah, if you have 50 more employees, you have to provide a health insurance plan on behalf of your employees. The employees may have to contribute to it, but there's an equitable thing under the statute, how much the employer has to pay, how much the employee has to pay. But if you're not eligible as an employee to get that, the theory is you're supposed to be able to go and be required to buy insurance, or you get a penalty on your tax return. That's no longer, the mandate's gone, but the impetus is still trying to create some kind of system where we all have some sense of health insurance. And that's a political question. A lot of people get upset about it. Like, why can the government force me to get health insurance? But at the same time, the government forces us to do many things. And the concept is, in the long picture, the argument is that if people are insured, it will cost society less in the long run if we have at least a threshold of insurance for health benefits for everybody. And if you have kids, I have 7 kids. Well, they're older now. Well, actually, they're all still under my insurance. I have 7 kids, and I know when I was a young man, I wasn't covered under my dad's insurance when I was in my early 20s, and I had an ankle injury, and I remember paying a ton of money out of pocket. My dad ended up paying it, but the point is, I'm a big believer that there's certain things that are fundamental rights, right to freedom of speech, right to free from unreasonable searches and seizures by the government. But I also believe that health insurance is a human right, and it's not health insurance, but medical care is a human right. And so I kind of am a little liberal on that thing. But some of you, and I don't disregard the argument's legitimate. Why does the government have the ability to force me to buy health insurance if I don't want it? I think it's a very strong argument, quite frankly, under a free society. But there's counter arguments that it also creates a society that has a certain degree of, I don't know, dignity to make sure that we all have the ability to access good, excellent health care, and that we're all covered in some way. But anyways, that's way off track. You can completely disagree with me, and it's a legitimate argument to be against that. Otherwise, be well, guys.